Can an executor of a will, can a personal representative of a will sell land before a grant has been given? Welcome to Court Helicopter Explainer. We wish to thank you that you have supported us. Until now, we are 70,000 plus subscribers. Our vision is to reach 1 million subscribers so that this type of knowledge is disseminated to everybody. You are part of our history and we value you so much. Today, we are dealing with an issue about after death, succession matter. Can an executor of a will, can a personal representative of a will sell land before a grant has been given? This is where most people have bought land from the children who have been given letters of administration, but no grant has been confirmed. You have a will. Somebody shows you, this is the will. I have been appointed an executor. You buy that land. Yet, the grant, the probate letters have not been confirmed. This is what happened in the succession course of 945 of 1997 in the matter of the estate of Githaiga Thuku, alias Thuku Githaiga, alias Livingstone Thuku, deceased. This was a matter in the succession course in Nairobi. What are the facts in this matter? Section 79 of the Law of Succession Act, Cap 160, Laws of Kenya, provides as follows. The executor or administrator to whom administration has been granted shall be the personal representative of the deceased for all purposes for that grant, and subject to any limitation imposed by the grant, all property of the deceased shall vest in him as a personal representative. This person, all the properties vest on him pursuant to Section 79 as a personal representative. Paragraph 11. The vesting of this property of a dead person in a personal representative places the administrator in the same footing with the owner of the property. Section 79 should be read together with Section 82 and Section 83 of the Act. Section 82 sets out the powers of the personal representative, which include the power to deal with the estate which in any event vests on him. The powers include the power of sale or conversion. Section 83 sets out the duties of the administrator, which include the duty to get in the assets of the estate, all of which vests in the administrator. By virtue of Section 79, the property of a dead person vests only in the personal representative, who would be either an executor of a will made by the deceased or an administrator appointed by the court in intestacy. Only a personal representative can exercise the power set out in Section 82 and bear the burden of the duties set out in Section 83. That is the law. Now, this is where the problem is. Section 79, 82, 83 of the Act ought to be read together with Section 45 of the Act, which provides, except so far as expressly provided and authorized by this Act or by any other written law or by a grant of representation under this Act, listen, no person shall for any purpose take possession or dispose of Otherwise, it will be intermeddling with any of the property of the deceased person. It moves on to say, a personal representative shall have the following powers. 1, to sell or otherwise turn to account so far as seems necessary or desirable in the execution of their duties, or any part of the assets vested in terms of the think best. Let me put it very clearly in simple law. In part 3, no immovable property shall be sold before confirmation of a grant. That is where the law is. No immovable property can be sold before a confirmation of a grant. What does that say? The property cannot be sold until after the grant has been confirmed. Let us go to this case. What happened in this matter? The respondents herein bought the subject property from a person who had purported to have bought it from the children of the deceased before the representation had been granted to the estate. That meant that at the time of sale, the estate had not yet been vested into the purported sellers. They therefore did not have the power to sell it to anybody. As it had not yet vested in them, they could not pass a good title to anyone. Their conduct fell afoul of Section 45 of the Act. The act of purporting to sell the property of a dead person without authority amounted to intermeddling. What did the judge say? The sum total of the above is that the transaction between Daniel Muturi Wanjohi and James Kenya Wamaji, Peter Njau Wamanji, Simon Gishura Wamanji, and Willie Njoroge Wamanji over Nyandarua, Oljororok, Salient, 2712 on 16th April 1997 did not confer any rights at all over the subject property. Therefore, Daniel Muturi Wanjohi did not acquire any rights that he could transfer to anybody else, including the respondent. The respondents therefore have no right to occupy the property in question. My brother, this is land that was bought in 1997. The sons of the deceased sold land before the grant was confirmed. The grant, when we talk of confirmation of the grant, is the final orders where succession has been done, parties have come to court, it has gone to the Kenya Gazette, it has come back, the property has been distributed, the grant has been given. This was not done in 1997. In 2016, this is almost 20 years. 20 years. The title deeds that had been given, the land, all the people who had bought there lost their title. What are the lessons? This is the judgment of Justice Ougo, delivered and signed on 20th December 2016. What are the lessons here? Many people are buying land before succession is complete. Many people are funding the deceased siblings to go to court to do succession. And you pay, believing that once succession is over, you'll get a share of that land. Some have bought and gotten title deeds fraudulently. The judgment of this wakes you up. If you have not finished succession, you cannot sell. Whether you have been appointed as a personal representative, as an administrator of the estate, as an executor of the will, until the grant is confirmed, you cannot sell land. The law allows you can sell cows, you can sell trees, you can sell goats before they die, you can sell vegetables, you can sell maize cobs, but you cannot sell land. Wakili Dan Omari has advised you. If it is land, wait until somebody brings you a confirmed grant. Also, go to court and confirm that that grant is genuine. It is not a grant, a confirmed grant that has come from River Road, that has come from a cyber or a bureau. Only after the grant has been confirmed, then can you buy that land. Wakili Dan Omari, always together with Vivian, we bring you the law as it is. Keep watching. You are now smarter. You are now bright. Thank you.